whether you wear a badge or not. If you care about courage, clarity, discipline, and the price of decisions in the moment that define lives, you've come to the right place. This is where training meets consequence, where the law collides with human behavior, and the fog of uncertainty tests the limits of reason. These are the stories of pressure, of purpose, and what it means to hold the line when the world loses balance. I'm Don, a police officer, instructor, and founder of Forecast Securities Group, and I'll be your guide through the storm. Welcome to the Conditions Report.
Hello and welcome back. I'm Don. This is episode 15. The road to hell is paved with good intentions. If you've already been listening to the show, then you know the premise. And if you're new here, here's what you need to know. This is the weather forecast for street cops, detectives, and admin. It's what's coming and what's changing in the environment we work in. And before we go any further, a quick disclaimer. I'm not an attorney. Nothing discussed on this show is legal advice. I'm not speaking on behalf of any government agency or law enforcement agency, and the views expressed here are those of Forecast Securities Group, and they are an exercise of protected American free speech. If you need legal advice or guidance specific to your agency or jurisdiction, you should consult a qualified attorney. This podcast is for educational and informational purposes only. We're not here to judge the officers involved in these incidences or to second-guess decisions with the benefit of hindsight. The point is to learn from their hard-earned lessons on our behalf and improve as a team. In tonight's summary, this episode is going to be about the Supreme Court opinion case v. Montana. It reads like a clean reaffirmation of long-settled rule, but it lands in the field of new set of incentives. It was decided on January 14th, 2026, and the court held that officers do not need probable cause to enter a home to render emergency aid, which is not new. The Fourth Amendment standard is what the court said in Brigham City v. Stewart in 2006, and officers may enter without a warrant when there's an objectively reasonable belief or basis for believing an occupant is seriously injured or immediately threatened with such injury. On paper, it sounds modest, and it's framed as a refusal to add probable cause gloss to an emergency aid exception that has always been keyed to the objective reasonableness. In the real world, though, the holding will be read by supervisors and administrators as a ratification of entry, and by officers as a narrowing their margin for error. It takes a category of calls that already produce the most after-action scrutiny, more violent outcomes, and the most moral injury for responders and places the finger on the scale on the side of intervention. The operational problem is not that officers in case had bad intentions. The operational problem is that good intentions backed by legal authority have a predictable trajectory in government institutions. They travel upward into policy memos and training bulletins, then down into expectations, and then directly into officers' decision calculus at the threshold. When an incident later turns violent, that same institution that signaled the entry as the quote-unquote responsible choice will evaluate the use of force under a separate body of law that is far less forgiving of escalation, especially in mental health encounters where there's little or no suspected crime and limited government interest. So tonight, we're going to walk through case carefully, derive the facts from the opinion itself, and then compare what the Supreme Court just said about emergency aid with what the Ninth Circuit has been saying about mental health encounters, including Scott v. Smith, Heyer v. City and County of Honolulu, and we'll also touch on Hayes v. San Diego and some other cases. Because California officers are going to feel this tension in a uniquely sharp way. State law incentivizes to prevent suicide by doing less or very little, and federal constitutional incentives are to intervene and the use of force environment that punishes officers for the very confrontation that these pressures can create. So this is the situation brief. Let's get into it. Here's what happened, and this is as the Supreme Court describes it in its ruling. William Case was on the phone with his ex-girlfriend, J.H. During that call, Case told her that he intended to kill himself. She believed that he had been drinking, and she testified that she tried to talk him out of it, but could not. And that as the call went on, he became more, quote-unquote, methodical. about what he was going to do. She heard Case say things like he was going to get a note, which she understood as a suicide note. She then heard a clicking sound like the cocking of a gun. She told Case that she was going to call the police, and he replied that he would shoot them all too. Then she heard a pop, followed by silence, just dead air. She called out his name and received no response and concluded that he had quote unquote pulled the trigger. She called 911 and drove to his house. And this is not a criticism of the caller, it is the reality check about information quality. In policing, we treat reports like this as leads, not conclusions. They can create credible information, but still be incomplete. They can be true in a broad sense and still wrong on the details that matter for constitutional scrutiny. They are, in a strict evidentiary sense, somewhat third-party information filtered through emotion, distance, and interpretation. That does not make them worthless, but it makes it something that should be handled with humility and tested against time, observations, and officer perceptions, especially when the next step is crossing one of the most protected thresholds in American law. 3 officers would eventually be dispatched to do what one officer described as a welfare check on a suicidal male. They met JH outside of Case's house and assessed the situation as quote unquote very serious. Based not only on what she reported, but what they already knew about Case, the officers were well aware of his history of alcohol abuse and mental health issues. They knew he had previously threatened suicide at school where he worked, and they knew he had once seemed to attempt suicide by cop by confronting police in a way that would likely provoke a lethal response. They knocked and they called out. They yelled into an open window and received no response. They looked into the house and they observed facts that, in the court's retelling, became corroboration. Empty beer cans, an empty handgun holster, and what looked like a suicide note. They did not see Case, they did not see blood, and they did not hear movement indicating distress. They did not have direct first-hand sight of any kind of injury. What they had was silence, circumstantial indicators consistent with self-harm, and a reported pop that they did not personally hear and could not independently confirm. Then comes the fact that should make every officer pause. The officers did not immediately enter. They waited approximately 40 minutes after they arrived. You cannot simply hand wave 40 minutes away. 40 minutes is either enough time to call for a coroner or enough time for the imminent part of imminent threat to evaporate. If the emergency was truly imminent, the delay is morally hard to justify. And if the delay was operationally justified, then the emergency seems to be legally hard to justify as well. The court resolves that tension by focusing on the objective reasonableness. But officers and agencies need to grapple with the operational meaning of the delay. It means the scene was not Brigham City. It means the officers themselves were unsure whether entry would save a life or ignite a fight. It means that time was available for planning, containment, and deeper assessment, but the decision still ultimately turned on inferred peril rather than a direct observation. The opinion says exactly that. The officers considered the possibility that Case had already shot himself and might be inside quote-unquote bleeding. At the same time, though, they worried that if he remained unharmed, entry could spark a violent confrontation. So they equipped themselves with long barrel guns and ballistic shields before going in. And that detail matters because it shows the duality of this call. It's not purely a rescue. It was a high-risk threshold crossing into an environment where the occupant had threatened to shoot police. They entered through the front door, announced themselves, and moved through the house. Case did not answer. He was hiding in a bedroom closet upstairs, and when an officer entered that room, Case threw open the closet curtains, emerged holding a black object that looked like a gun. Fearing he was about to be shot, officers fired his rifle. Case was hit in the abdomen, and an ambulance was called, and the officers would later find a handgun right next to where Case was standing. Case would be charged with assault on a police officer, and he would move to suppress the evidence, arguing that the entry violated the Fourth Amendment. The Montana trial court denied the motion on the ground that officers were responding to a quote-unquote emergency. A divided Montana Supreme Court upheld the entry under the state's community caretaker doctrine, reasoning that after Caniglia v. Strong, rejected a broader federal community caretaking rule for warrantless home entries, Montana's doctrine survived because it required an actual emergency. The Supreme Court affirmed the judgment, but it did not bless the Montana Supreme Court's reasoning. That language matters for agencies because it signals that the right doctrinal framework is an emergency aid framework, not community caretaking. And that's where the danger begins, because community caretaking in police culture often means we're here to help, while emergency aid in a constitutional doctrine is supposed to be narrower and anchored to a belief of serious bodily injury or imminent death, or the imminent threat of such injury. Conflating them is how authority expands unchecked. So the current conditions are as follows. To understand why this puts officers between a rock and a hard place, especially in California, you have to hold the two legal climates in your head at the same time. First, you have the Supreme Court's emergency aid line of cases, which are built around quick judgment in ambiguous emergencies. Brigham City, for instance, involved officers arriving at a home, observing an ongoing fight with visible injury. Michigan v. Fisher, police officers respond to a complaint of a disturbance. Upon their arrival, officers are found with a household in considerable chaos, a pickup truck in a driveway with its front windows smashed, and 3 broken windows on the house with glass still on the ground. Officers also noted a considerable amount of blood on the hood of the pickup, clothing inside, as well as one of the doors in the house. Through a window, officers could see a respondent, Jeremy Fisher, inside the house, screaming and throwing things. The back door was locked, and the couch had been placed to block the front door. Officers knocked, but Fisher refused to answer. They saw that he had cut his hands and was bleeding profusely. They asked whether he needed medical attention. Fisher ignored these questions and demanded, with accompanying profanity, that officers go get a search warrant. Officers then pushed the front door open, ventured into the house, and they saw Fisher pointing a long gun at them. They withdrew, and in those cases, the scene itself was considerable corroboration. The court's reasoning in case expressly leans on emergency aid lineage and repeats the same objective reasonableness standard. But case also shifts the emphasis in a way that matters operationally. The court treats the third-party report plus circumstantial observations plus officer knowledge of prior mental health history as enough to satisfy the, quote, objectively reasonable basis, unquote. And it refuses to translate that standard into probable cause. That matters because in the hands of leadership, not probable cause becomes a quote-unquote low bar. And the low bar becomes, well, why didn't you go in? Second, you have to understand the Ninth Circuit's climate on mental health encounters and force. In Scott v. Smith, the Ninth Circuit evaluated a call where Scott, in a mental distress, called police for help. The published opinion explains that he was unarmed, not suspected of a crime, and viewed in the light most favorable to the plaintiff, did not present a risk to officers or others. Officers used physical force and body weight to restrain Scott, who lost consciousness and was later pronounced dead. The Ninth Circuit held that a reasonable jury could find the force constitutionally excessive, and it held that the law was clearly established, citing Drummond v. City of Anaheim as the establishing case that bodyweight force on the back of a prone person in those circumstances was excessive. And the reason Scott matters here is not because Case is a bodyweight restraint case. It matters because Scott is part of a larger Ninth Circuit posture. When there is no suspected crime and no immediate threat to others, the governmental interest is low, even if the person is in crisis. Help does not automatically elevate governmental interest. In fact, help can lower the justification for force because the objective is welfare, not control. The person is often erratic, frightened, and physically reactive to restraint. That's not moral condemnation. It is the predictable collision of crisis behavior and coercive control tactics. In Heyer v. City and County of Honolulu, it pushes in the same direction. It involved a prolonged standoff with a barricaded individual suffering from mental illness, leading to serious force decisions over a period of hours. When the Ninth Circuit's willingness to scrutinize these tactics and the progression of force in that context signals the same structural reality. When police decide to force a resolution in mental health calls, courts later examine whether the resolution was even necessary in the first place, whether escalation was avoidable, and whether officers created the conditions that made force likely. Now put these two climates together and imagine you're a patrol officer or a watch commander in California. On one hand, after case, supervisors could argue that there's a reasonableness to enter a home when you have objectively reasonable belief that someone may be in peril, even if the information is third party, even if its corroboration is circumstantial, and even if the occupant is not threatening anyone but themselves. But on the other hand, after Scott, Drummond, and other cases, if that entry leads to a physical confrontation and the person is not suspected of a crime and is not threatening others, the governmental interest in using force is limited at best. And the force you use is more likely to be judged as excessive. That is the rock and the hard place. Entry increases the probability of confrontation. Confrontation increases the probability of force, and force in the Ninth Circuit is judged against the backdrop that is increasingly skeptical of escalation in mental health calls. And this is where supervisor pressure can become a downstream liability generator. Administrators and supervisors have incentives that are not aligned with the realities of police work. They are often evaluated on outcomes. They're evaluated on whether the department, quote unquote, did something. They're evaluated in city council meetings and press conferences, and they live in a world where worst sentences are you just left them there or you did nothing. And Case gives leadership a clean lined quote. The courts say the Fourth Amendment did not require officers to leave Case to his fate. I predict that phrase will be weaponized. It will become the moral cudgel. It will be used to pressure entry when the scene is static, even when the information is third party, when the time has already diluted any claim of eminence, and when the person's only apparent target is themselves. Here's my concern. This case scares me because supervisors and administrators will use it to press the issue, to avoid walking away, and to force officers into violent encounters where there is little to no governmental interest and often no moral or ethical interest as well. If a person is alone inside their home, threatening only self-harm, the governmental interest is not zero. But it is not the same as an active shooting, a hostage situation, or a credible threat to third parties, or a crime in progress. It is primarily an interest in welfare and rescue, and that interest does not automatically justify a coercive entry when coercive entries predictably increase the likelihood of violence. The Supreme Court's opinion does not grapple with the 40-minute delay in a way that should satisfy any officer's instincts. If you truly believe someone is inside bleeding out, urgency should look differently. If you wait 40 minutes, that signals that you are not acting on a direct emergency evidence. If you act on inferred risk or possible future harm and you are balancing that inferred risk against the real risk, that entry will provoke a deadly confrontation. The court's legal conclusion may still be quote unquote reasonable, but the operational truth remains. The longer the delay, the harder it is to describe the situation as immediate, rather than a high risk welfare check. And that balancing is exactly why it's hard for officers. It's also exactly why it's dangerous for supervisors to turn decisions into blanket go-in exceptions. In the field, you do not get to separate emergency aid purposes from the we might get shot when we cross a threshold reality. And the court can talk about purpose. The street cop has to talk about angles, cover, distance, time, and the probability that a suicidal person with a gun will redirect that gun at police when possible force is the issue. Now let's add on California's Hayes layer, and you tighten the corridor even more. Hayes v. County of San Diego is not the same doctrine as Case, but it is part of California's real operating environment because it reflects how courts and litigants examine pre-force decision-making in suicidal person calls. Hayes is tied to the broader question of whether the chain of events leading up to force itself can be scrutinized as unreasonable. In plain English, the environment in California officers live in is one where the question is not only was the final shot reasonable, but can also be was your approach, your entry, your proximity, your decision to use a force and confront the person, the choice that made the violence predictable. That's the impossible corridor. If you do not enter, someone will say you left them to their fate. If you do enter and the subject presents a weapon and force follows, someone will say you created the confrontation by entering. And in mental health calls with low governmental interest, your force was constitutionally excessive. The officer becomes the hinge point for the institutional discomfort. That is not sustainable. And this is also why the community caretaking label matters. In Caligula, they rejected a broad community caretaking rule for home entries. Absent the need to render emergency assistance, community caretaking sounds benign. It sounds like service, it sounds like helping, the identity of policing. Emergency aid is much narrower. It is supposed to be anchored to a credible belief of serious injury or imminent threat. The Supreme Court, in case, insists emergency aid is the right category, but it says that it is not adding a probable cause requirement. But leadership culture often slides caretaker and emergency aid back together. It does this because it feels good to do it. It does this because they align with the public expectation, and it does this because it sounds responsible. And that erosion is what will get officers hurt. It will create a pressure to enter based on discomfort rather than necessity. And in states like California, where the Ninth Circuit's mental health force jurisprudence is already squeezing governmental interest and scrutinizing escalation, it's a recipe for more violent outcomes and more personal liability. If you want this conundrum in the plain language, it's this. The law is pulling officers in two different directions at one time. The Supreme Court tells you it can be reasonable to enter without probable cause when you believe someone may be in peril. And the Ninth Circuit tells you force is hard to justify in mental health encounters where there's little to no crime and no danger to others. And it scrutinizes the entire chain of escalation that leads to the force. The supervisor who quotes case to demand entry is not the one who will be sued for the force that follows. The officer will be. That is the current condition, and it's not an academic doctrinal debate. It's a leadership problem, and it's about what gets demanded of officers and what officers get blamed for when the demand produces exactly the kind of violent encounter everyone claimed they wanted to avoid. That brings us to today's leadership navigational aid. The road to hell is paved with good intentions. The precise origin of this phrase is unclear, and it's appeared in many variations across history. The road to hell is paved with good resolutions. Hell is full of good wishes. The descent to hell is easy. The wording may change, but the meaning endures because the warning is not about villains. It's about institutions. It's about what happens when power operates under a moral alibi. Bernard of Clairvaux is often associated with this warning not because he coined the phrase, but because he embodied its lessons. Bernard was not a casual commenter or poet writing for entertainment. He was a monk, a theologian, and a political force in medieval Europe. He influenced popes, shaped policy, and mobilized mass movements. When Bernard spoke with moral certainty, his words carried momentum. That momentum bypassed prudence, and it converted conviction into action. His most famous public act was preaching the Second Crusade, a campaign presented as a moral and spiritual obligation and later remembered as a disaster. The critical issue was not the details of the medieval warfare. It was the issue of mechanism. The crusade was justified by intention, and it was framed as rescue and religious duty. It was driven by the conviction that action, not restraint, was the only moral posture. In the final years of his life, though, Bernard was deeply affected by the Crusade's failure and the criticism it directed towards him. In the Book of Considerations, particularly Book 2, he addressed these events not with an apology, but with a theological explanation. He argued that the defeat resulted from the sins and moral failures of the Crusaders rather than from any error the cause itself carried. Intention may have been pure, but the outcome was still catastrophic. The same mechanism is a modern warning for leadership reading cases like Case v. Montana. When a supervisor reads a case and says, "We can't leave people to their fate," the statement sounds humane, it feels morally correct, but it also becomes a pressure mechanism. Officers do not operate in a world of slogans. They operate in a sometimes violent reality. They work in a world where a suicidal person with a gun can become a police ambush in the moment the door opens. They work in a world where legal authority to enter does not carry warranty guarantees against consequences of entry. And they work in a world where the same organizations that demand action will later ask why the encounter turned bad. This is why the leadership navigational aid matters for supervisors. Your job is not to convert every tragedy into a police problem. Your job is to distinguish between an emergency that requires coercive intervention and a crisis where police presence increases risk. Your job is to protect your people from being used as a moral instrument that satisfies an institution's discomfort with inaction. Good intentions are not enough. If your expectation predictably produces violence, your intentions become irrelevant. That brings us to the extended forecast. The forecast after Case v. Montana is that the pressure gradient will increase. In the next year, you will see this case quoted in briefings and trainings. You'll see it used as a justification for entries that are factually weaker than the ones in the opinion. You will see objectively reasonable basis treated as a low bar, and you will see the 40-minute delay minimized because it complicates the calculus. And you'll see third-party reports treated as sufficient on their face rather than as information that should be tested through corroboration, observation, time, and coordination with crisis resources. At the same time, you will continue to see the Ninth Circuit force decisions in mental health contexts that punish escalation and scrutinize governmental interests at each step. When those two trends collide, the people caught in the collision will not be appellate judges and administrators. It will be patrol officers, sergeants, and incident commanders standing at doors in the middle of the night, trying to decide whether they are about to trigger a fatal confrontation, save a life, or walk away. The way forward is not denial. It is not bravado. It is leadership discipline. It is policy that does not treat police as the default mental health interventionists. It is supervisor training that distinguishes true emergency aid from community caretaking instincts, and that forces leaders to articulate out loud what the governmental interest actually is before they pressure officers into making an entry. It is the willingness to accept that doing nothing is sometimes the most responsible option. Case v. Montana will be cited for years, and the only question is whether your leadership will use it as permission slip to force the issue or a warning that authority expands easily and the cost is paid in the people standing at the door. As we close, let's remember the point of the show is not to pass judgment or revisit decisions with the benefit of hindsight. It's to learn as a team and improve. We're all here. We're all leaders. Keep the leadership navigational aid in the back of your mind. The work is complicated, the environment is demanding, and none of us get it perfect. Stay hungry, stay humble. I'm Don, and this has been the Conditions Report. Be the calm in the storm, the clarity in confusion, and always influence the weather.